Hello, my name is Professor Shiraditya Rakshit. Property Rights, Part 2, Hindu Law. Learning Objectives. To have an in-depth knowledge of the various succession and inheritance laws in India from 1956 to 2005, to have knowledge about the observations and recommendations made by the 174th Law Commission report, and to understand customs and laws related to ownership of private land and property, to have an overview of the changes that have been brought about in inheritance laws to make them gender neutral, to understand the existing discrepancies within Hindu succession laws even after the 2005 amendment. Introduction. This module continues the discussion stated in the previous module, Property Rights 1. The earlier module already demonstrated that property rights in India, which are governed largely by personal religious laws, are discriminatory against women in nature. There have, however, been several attempts by deliberative bodies to remedy issues related to discrimination in this module. Attempt has been made to highlight the steps taken by the legislatures and key developments that sought to end the discriminatory elements of property rights. The 174th Law Commission report, Discrimination against daughters with respect to right in property, was removed in certain states by state amendments to HSA 1956. The 174th Law Commission was set up in the year 2000 to propose amendments to the Hindu Succession Act 1956 nationally, in order to remove laws that continued to allow gender disparity. The introduction of the 174th Law Commission report states as follows: discrimination against women is so pervasive that it sometimes surfaces on a bare perusal of the law made by the legislature itself. This is particularly so in relation to laws governing the inheritance or succession of property amongst the members of a joint Hindu family. It seems that this discrimination is so deep and systematic that it has placed women at the receiving end. Recognizing that this Law Commission, in pursuance of its terms of reference, which inter alia oblige and empower it to make recommendations for the removal of anomalies, ambiguities, and inequalities in the law, decided to undertake a study of certain provisions regarding the property rights of Hindu women under the Hindu Succession Act of 1956. The Law Commission observed that despite the constitutional guarantee of equality on the basis of sex, there was still discrimination against women, which was prevalent not only a woman's husband family but also her natal family discriminated on the basis of sex. The Law Commission also observed that a large number of fraudulent partitions took place right before the state amendments to HSA 1956 was passed, so as to defeat the purpose of the amendment, and no compulsory property was therefore available to daughters. The Law Commission recommended various revolutionary changes analyzing the existing laws and the various state amendments to the HSA 1956. It suggested a drastic reform in the law so as to resolve the gender inequalities. It combined the Kerala and the Andhra Pradesh model. The Law Commission noticed that the Andhra Pradesh model still excluded daughters married before the commencement of the Act from the purview of compulsory property. After much deliberation, the Commission came to the conclusion that daughters married before the Act must have already received gifts on marriages and to prevent tension amongst the family. Daughters married before the enactment of the Amendment Act were suggested to be excluded from the purview of the Act. In order to redress continuing inequalities, the Law Commission suggested the Section 23 of the HAS that places restrictions on the daughter to claim partition of the dwelling house should be deleted completely. The Hindu Succession Amendment Act 2005 HSAA 2005. Based on the recommendations of the Law Commission report, the Hindu Succession Amendment Bill was introduced in Parliament on 20 December 2004. The bill was passed by both the houses in August 2005. The bill received presidential assent in September 2005 and the bill came into force on 9 September 2005. Although it was recommended by the Law Commission to exclude daughters married before the enactment of the Amendment Act from getting a right in Kopasni property, Parliament wanted to achieve equality in every sense and hence daughters were given the same position irrelevant of their marital status on the date of enactment. The most important change that the Hindu succession brought was to amend Section 6 and to give the daughter the same right by birth as was given to a son. It also brought the female line of descendants at par with the male line of descendants by giving children of a predeceased daughter the same rights of representation as children of a predeceased son. Another challenge that the HSAA 2005 brought was abolition of the doctrine of survivorship in case of male Hindus. Notional partition of the male's undivided share before the amendment was restricted to a condition of him leaving behind a class 1 female heir or a son of predeceased daughter. The 2005 amendment has done away with the condition and affects a notional partition in every case. That is, if a male Hindu dies intestate, his undivided share would not pass to the surviving Kopasanas but will devolve the testamentary succession or rules governing intestate succession. Moreover, Section 4, Clause 2, which prevented the applicability of HSA 956 to agricultural land, has been abolished by the amendment to create gender just laws. This aim is to have gender equal laws create an anomaly as agricultural and transfer and alienation of agricultural land under the state list, but intestacy and the succession are under concurrent list. The HSAA 2005 has further repealed Section 23, which prevented the female heir from demanding a partition of the dwelling house as long as the male heir were alive. Now, a female heir can demand partition of a dwelling house as well. Repealed Section 24, which disqualified the widow of a predeceased son and the widow of a predeceased son of a predeceased son if at the time of opening of the succession the widow had remarried. Hence, widows, even they have remarried, have a right to inherit. Section 30 permitted a male Hindu the power to make testamentary disposition of his property, including his undivided shares, has been extended to include a female Hindu as well. Now, even a female Hindu can make a testamentary disposition of a property, including her share in the Kopasni property. Although HSA 1956, after its amendment, has brought about radical changes in the structure of a Hindu joint family, but certain anomalies remain. The Act does not define compulsory property partition, but uses the terms in the devolution of property. The Act has altered the very concept of ancestral property and compulsory property. Ancestral property before the enactment of HS 1956 included property inherited by a male from ancestors in which his son, grandson, or great grandson had right by birth, but after enactment, property inherited from ancestors no longer gives right by birth to the descendants of the person inheriting the property. When co-partners are all members of same joint family, anomalies exist in the case of a daughter who has been made co-partner in her natal family, but after marriage she remains co-partner in her natal family and becomes the member of her husband's family. It is still unclear if doctrine of survivorship is still applicable for a female Hindu, or if her children forms a co-partnery with her after partition, when section 14 of the Act expressly grants her absolute rights in all properties. Land rights. In rural India, land is the most valuable asset and source of income. Many studies have shown a direct correlation between land ownership and the status of women in their society or community. Women in a rural India contribute towards 80% of the work on agricultural lands. However, it is rare for women to own agricultural lands. This is true even after the tremendous changes that have been made to inheritance laws. Even today, women rarely claim their legal rights of inheritance. In agriculture and other societies, jewelry and cash are given to daughters at the time of their marriage. This has typically been seen as a way to compensate women for leaving the ancestral home and compensate her for her share in her natal property. Very few instances have been seen where land was gifted during marriage, and the few examples that do exist tend to be restricted to very rich families. Typically, the value of the jewelry, cash and clothing given in to a daughter at the time of marriage was in no way comparable to the value of land. Customs associated with ownership in land and property. Some communities in India recognized a woman's right in land ownership. Matrilineal societies or bilateral inheritance practices evident in the southern and northeastern states of India and amongst tribal groups in the Garo tribe in Meghalaya. All property passes from the mother to the daughter, but the major portion of property, including land, passes on to only her youngest daughter, Nokna, who is chosen to receive such property. It is usually the youngest daughter. The male moves in with his in-laws after marriage. No male member of a family may inherit property. Even the sale acquired property of an unmarried man on his death is owned by his mother and would pass on to his female descendants. After marriage, the self-acquired property belonging to his wife would pass on to her descendants. Although it might seem like females own property to the exclusion of all males, the husband usually exercises effective control and has the power to override the wife's decisions in the management of properties. Lands in the Garo hills generally belong to the specific clans. These lands are mostly forested land. These lands are known as king lands. Land is not only individually owned but is held in custody by the husband of the inheritance of the founding household. The husband, a king, is given the power to manage and control the land, but he can not dispose or sell of the land without the consent of the wife. Amongst the Khasis within the Meghalaya and Assam, land is classified into commonly owned land known as the re-raid. This land is understood to belong to all of the clans comprising of the village community and privately owned land, which is known as Re-Kinti land. Even under privately owned land, the ancestral land under the customs could not be sold or purchased and is primarily under the control of the clan and could not be alienated without the consent of the clan. The youngest daughter is the primary heir to the ancestral property. If the youngest daughter dies without any female descendants, the property dissolves on the next elder sister. In southern India, the Nayars were a prominent matrilineal community. The joint family concept existed in communities which held the ownership of land. Land could not be inherited individually. Inheritance was brought a female line, but they had little control over the property. Customarily in the Hindu matrilineal families, women were seldom gifted land at the time of marriage, which would amount to their Sridhan. Only if a situation where she was actually given land would she have absolute control over the land. Laws related to ownership of private land. Before amendment of HSA 1956 in 2005, Before amendment of HSA 1956 in 2005, the Hindu Succession Act 1956 exempted agricultural land from the purview of the Act by virtue of Section 4, Clause 2. It said that for the removal of doubts, it is hereby declared that nothing contained in this Act shall be deemed to affect the provisions of any law, for the time being in force, providing for the prevention of fragmentation of agricultural holdings, or for the fixation of ceilings, or for the devolution of tenancy rights in respect of such holdings. The HSA 1956, before its amendment, did not touch upon the most valued form of property in rural India, which is agricultural land, and let it for the state laws to decide the order of devolution of such forms of property. There is a multiplicity of laws governing the devolution of agricultural property, as agriculture is under the state list. There were 3 brackets of laws which would apply to agricultural land. First, the Hindu Succession Act 1956 before its amendment. The second, the personal laws, and third, the tenurial laws, which specify the order and mode of devolution. Some of the tenurial laws do not state the mode of devolution in these cases, as do not conflict with the provisions of the HSA 1956. The rules of devolution under the HSA 1956 applied. Some of the tenurial laws specify the order in which devolution of the agricultural land would occur, and hence these laws, given the effect of Section 4, Clause 2 of the Act, took precedence over the personal laws and rules of devolution under the HSA 1956. Some tenurial laws specified HSA 1956 or personal laws would apply. Most of the state level land reform legislations and the land ceiling laws are gender unjust laws giving preference to the male lineage. Some of these laws, in addition to giving preference to agnatic succession, also exclude females. There is a vast difference in the state laws governing ceilings on agricultural lands holdings, which gives additional benefits to families with sons over those families without sons. Families with adult sons allowed to own additional land. There are also some laws which treat adult sons as a distinct unit, and they are allowed to keep as much land as a single family. Daughters are not treated at par with sons and are not treated as a distinct unit. Families with daughters are not even allowed to retain additional land. Even states like Andhra Pradesh and Tamil Nadu, which made a daughter a Kupasana before a central amendment was passed, they did not treat daughters as a separate unit to possess a land, but treated an adult son as a separate unit. It is only in the Kerala Land Reforms Act 1963 that a daughter is treated as a separate unit to receive land. After amendment of HSA 956 in 2005, the Hindu Succession Amendment Act 2005 deleted Section 4 Clause 2, that is the non-applicability of the Act to agricultural land. It does not explicitly amend the Act to include agricultural land under its purview. The deletion has led to a series of different types of conclusion as to whether now agricultural land, which is a state subject, will be covered by the HSA 956. Article 31 Clause B of the Constitution states that the validation of certain acts and regulations without prejudice to the generality or the provisions contained in Articles 31A, none of the acts and regulations specified in the 9th schedule nor any of the provisions thereof shall be deemed to be void or even to have become void on the ground that such act, regulation or provision is inconsistent with or takes away or abridges any of the rights conferred by any provisions of this part, and notwithstanding any judgment, decree or order or any group, court or tribunal to the contrary, each of the said act and regulations shall, subject to the power of any competent legislatures, repeal or amend it, continue to be in force. All the major tenurial laws under the 9th schedule therefore protect the validity of land reform legislation from being challenged. The impact of the amendment was studied in detail by Lancier. The published study is the first substantial evaluation of the impact of that amendment and indicates that many women have yet to benefit from the legal changes. The survey of more than 1,400 women and 360 men in agricultural districts with large numbers of women farmers in Indian states like Andhra Pradesh, Bihar and Madhya Pradesh found that just 1 in 8 women whose parents own agricultural land inherit any of it. Apart from these results, the report also found signs of progress. In Andhra Pradesh, where women gained equal inheritance rights more than 20 years, and thanks to a progressive state law, rates of land inheritance among women were significantly higher than the other two states surveyed. 34% of women in the Andhra Pradesh sample had either inherited parental land or expected to do so, compared to 8% in Bihar and 7% in Madhya Pradesh. Consequently, there is still some ambiguity over devolution of agricultural land, as land and agriculture continues to be seen as state subjects while succession inheritance laws form a part of the concurrent list of the Constitution. Conclusion: there have been major changes to inheritance laws in India with the introduction of the Hindu Succession Amendment Act of 2005. The 2005 amendments have managed to bring about equality and to treat a daughter at par with a son. Despite this progressive legislations, questions regarding the successful implementation continues to exist. A study conducted by Landesa on the implementation of the Hindu Succession Amendment Act 2005 reflect that women are not enjoying the benefit of the progressive amendments. The report also demonstrated that cultural practices often defeat the intention of the amendments. For instance, findings of the report showed that women did not want to inherit land from the parents, as they were wary of the strain that would result if they were seen as wanting land, and that women were also concerned about potentially being looked down upon by the community for going against established social norms. Additionally, the report found that women were uncertain about their legal rights and of the legal settlement to their parents' property. It was also found that even though the amendment sought to bring daughters at par with sons in situations where women inherited land, they did not get an equal share as the sons. This demonstrates that despite the intention and provisions of the 2005 amendment, a gap between the legal provisions and the reality on the ground continues to exist. For women to achieve social equality and to become more empowered, it is essential that women should be able to access and control land and property that they have legal rights to, in order for them to make them informed and personal choices regarding their life notions. Access to land will enable women to live with dignity and to not have to suffer or make compromise regarding their quality of life because of their need for physical shelter and economic security, which unequal inheritance laws currently enforces. Identifying methods to narrow the gap between the existing legal provisions and their full and effective implementation must therefore now be the priority of the government to ensure constitutional obligations to end discrimination between and to provide equality between men and women are upheld. Thank you.